Hey everyone, welcome back. Today we're covering 3 sovereign citizens in court, and the final case follows up on the Indian sovereign citizen who previously showed up with his own so-called tribal council. Let's get started and see what happens today.
Oh, I was just gonna call Mr. Trammell.
Ready? 26 CR 921 Trammell appearances.
Daniel Cohn on behalf of the people. Mr. Trammell is present,
Pro se.
on bond, pro se. Looks like last time we were in court, he was asking for extra time to potentially hire counsel.
I had, on April 6th, I indicated to you that you should apply for the public defender's office. Did you do that?
Yes, ma'am. No, I
Okay.
did not.
You didn't qualify?
In that time, a lot's transpired.
Okay.
Did you get the notice that I submitted into the case?
The letter,
Yes.
did you get it, Mr. Cohen?
Try me to check real quick. Yes, I do see that.
So your, did you have first and foremost, I'll indicate to you that I am not an administrative law judge.
Okay.
All right. But it looks like based on what you were asking in here is that you're asking for restitution. That is not something that can be done out of this case.
Okay.
All right.
Okay.
And you're invoking a number of other,
Yes, I mean,
pro-
given the nature that there's no injured party or no damage to property, I have a concern with an administrative court hearing
I'm not an
judicial matter.
administrative court.
You're not, this is not an administrative
No,
court?
no, this is part of the judicial branch. This is
an
not part
Article
of
3
the,
court?
excuse me?
This is an Article 3. We're in Article 3 court.
This is not an administrative court.
Are
This
we
is
in an
a
Article
part of
3
the-
court?
I mean,
That's just a simple question. I'm not trying to be difficult. I want to know what I'm walking into before
Your Honor,
I'm not trying to be difficult at all.
I would just ask
Given the
that,
nature of what's going on here, I need to know exactly what I'm,
so last time we were in court, this court agreed to continue, but said the court would expect to move forward on this date. At this point, the people would just ask that the court enter a not guilty plea on behalf of Mr. Trammell and set it for a disposition date. It sounds like Mr. Trammell has some philosophical beliefs about the system that don't exactly match with the facts of his situation, but that's neither here nor there.
you're citing the United States Constitution and we're governed here.
Absolutely.
I'm appointed by the state. So
Absolutely.
this is not a federal court. This is a
But the-
state court. So no, this is not an Article 3 court. This is a state court. All right. This is not under the United States Constitution. I am not appointed. I wasn't nominated or confirmed by any federal body. This is a state court. So
Yeah, but
no, this is
did you
not.
take an oath to the Constitution? And are these state rules repugnant to that oath? That's the only question I
Yes,
have.
yes, there are state rules, and you are charged in this case with having a dangerous weapon, possessing a dangerous weapon, and having a large capacity magazine, which is prohibited. That's what you're charged with under the state law. So how do you want to move forward? You don't have an attorney. We're currently set for a appearance of counsel, so let's go ahead and set this for arraignment. All right?
Set for arraignment?
Yes, so at that point, or you can do that today if you'd like. Plead
No.
guilty, you can either reach an agreement or you can enter a not guilty plea. Do you want to enter a not guilty plea?
No, I do not.
What do you want to do today?
Set this for another arraignment. I need more time to figure out what it is.
So why don't we come back next Friday at 8:30, and at that time, it'll be set for arraignment.
That wraps up our first case. He already has another court date ahead and plenty of problems waiting for him. Somehow, he still thinks representing himself is the best strategy, so this situation is probably about to get even more ridiculous. At this point, he may need more than confidence to escape before he realizes it.
All right, so we have you here on a no valid operator's license. It looks like I'm still showing that it is expired. So what would you like to tell me today about the infraction?
Well, I'd like, Your Honor, if the court pleases, to certify the bond of subrogation, if you please.
Certify the bond.
Yes, Your Honor.
Can you? Okay. One moment.
Yes.
So what would you like me to have certified?
The bond of subrogation.
What is the bond of subrogation?
You don't know?
Why don't you inform me? Is there a document that you have?
I can have the Justice Department send you one.
For what?
The bond of subrogation.
So a subrogation agreement,
Subrogation is a bond.
correct?
That's a bond that you place on my name.
I have not placed any bond on your name.
Well, this municipality most likely has.
You are Alan Lee Waddell,
Correct.
okay? And so there's,
See, when this court is, if you hammer me, all that money in that bond goes to the IMF.
there is no bond. There's an infraction with a fine amount. So if that's what you want to tell me today, we're here for a contested hearing. I haven't
Sorry,
heard
Your Honor,
anything that,
latches and curs. Are you familiar with the Constitution? Latches
I
and
am.
curs, right? I motion to dismiss.
Okay, motion to dismiss on,
Next, we move to another hearing from Washington. Here, the defendant repeats questionable internet talking points, but everything falls apart when the judge asks him to explain what he actually means. Suddenly, those confident arguments completely disappear, leaving him struggling to explain even the claims he just made in open court. He has no answers.
Sorry, Your Honor, you're supposed to know the law.
okay?
Latches and curs.
All right, what legal authority do you have for your motion to dismiss beyond you don't think I know what I'm doing?
That will come from the Justice Department, Your Honor.
All right, you were stopped on February 25th, 2026?
According to Eric, the Kelso cop,
Okay,
is he present?
did
is
you,
Eric present?
did you subpoena him?
I did, and
Did you file
I
proof of
also
service of the subpoena?
excuse me,
Did you file proof of service of the subpoena?
I did. I filed a notice of liability.
That's not a service
It's,
of proof of service.
it's a certified sign. It's a signed affidavit.
What
You should
signed
have that.
affidavit do you?
It's supposed to be in your possession.
I have it.
Okay. Have you read it?
Yes,
It's notarized.
okay.
It's a notarized affidavit.
Indiana Bill of Rights. None of this is binding on this court.
Those are case law, Supreme Court case law. Standing.
Indiana Article 1 Bill of Rights is not case law.
Well, we're applying it to.
We are not applying Indiana Bill of Rights to Washington.
Your name will
Court.
appear here.
All right. Mr. Waddell, I have in front of me the officer's narrative indicating that he stopped you on February 25th, 2026, driving a maroon Chrysler PT Cruiser on the northbound 1400 block of South Pacific Avenue with its
Objection,
left
Your
and center brake light not functioning, initiated the traverse stop, identified himself verbally as Alan Waddell, stated he left his insurance back at his house and was unable to provide proof of insurance. The check of his DOL showed that it expired September 22nd, 2022. The photograph on Waddell's DOL record matched the driver, confirming his identity, and he issued the infraction. And you were warned about not having insurance and not having brake lights active. All right.
I informed the officer, Your Honor, at the time that there is no contract. The contract, the license, which is a contract, has expired. almost 5 years ago.
Yet you were driving
There is no
on-
contract.
You were driving on a public road. Okay, I'm gonna find the infraction committed
no
at the
bearing
full
on it.
amount of $564. You will have
I'm-
60 days to either pay in full or set up a payment plan.
I will sub this, and
What was that?
I will have to recommend it. I must recuse you, Your
Okay, you
Honor.
can file that with the, you
At this
can
point in
make a
time.
motion, but I've made my ruling at this point.
I'm motioning for a mistrial, and I'm going to recuse you.
Okay, I'm
from this case.
denying those motions as they are not timely nor relevant at this point.
Under the
So your infraction
Constitution-
has been committed. If you would like to file motions to
You are
appeal
in direct
this,
violation
go
of the
ahead.
constitutional rights, Your Honor.
All right,
You
Mr.
are
Waddell, that'll
moving-
be all for today.
This is the ultimate pot calling the kettle black moment. The judge clearly understands the term he's discussing, while the defendant clearly does not. He has no clue.
A readiness conference. I'll just make a record that Mr. Schmidt did file some further legal filings. I have issued a written order denying those. And so I won't take additional argument regarding the arguments that Mr. Schmidt already made. I just found that they were not based in law, and so I have denied those. Today, we're just going to find out if people are ready for their trial. So for the prosecution, we are set for trial next week. Will you be ready to proceed?
Your Honor, and I wanted to provide the court notice that when I took over this case, I reviewed it, and I will not be proceeding on count 5, the obstruction of government operations charge. I did some case law research. I don't think it fits under several cases. So at trial, my plan is to only proceed on counts 1 through 4.
Okay, so you're formally moving to dismiss
Yes.
count 5? Okay. Mr. Schmidt, then that leads only traffic offenses. And I guess he's charged with failure to provide proof of insurance, so he'd still be entitled to a jury trial as there's potential jail on that offense up to a year. Mr. Schmidt, did you want to speak with the prosecution to see if you could come to some sort of resolution in the case based on that they've dismissed that misdemeanor case? We're taking a record, so I do need you to answer out loud.
It's not a misdemeanor. It's a felony.
Okay. Well, the obstructing is a misdemeanor to Colorado law. So that's been dismissed. Now what you have faced with you is 2 counts of unregistered vehicle or a count of fictitious plates, a seatbelt not used, and failure to display proof of insurance. So the question for you is it sounds like you would still like to proceed to trial, or do you want to talk with the prosecution to come to some sort of resolution?
No, ma'am, but while I'm sitting here trying to contemplate whether or not I'm going to file judicial criminal complaint against you and sue you personally, who said that I was a sovereign citizen? You did. I never mentioned a sovereign
Okay,
citizen.
Mr. Schmidt, I'm going to give you 5 minutes to make your record, and then I'll
That's
I'll
fine.
go ahead.
Charge you 4 counts of defamation, libel, and slander. Ready to do that. I want everything from the last hearing vacated. I want this stricken from the record. To say I'm a sovereign citizen is an oxymoron, number 1. Number 2, you're automatically falsely labeling me a domestic terrorist. And I object.
And that's where this hearing ends. It's basically the legal version of jumping from 30,000 feet without knowing how the parachute works, then hoping everything works out before you hit the ground.
Make any
That's
other additional
risky
record that
today.
you'd like to make.
And I got your motion or your order 3 days ago. It says motions. I only filed 1 motion. The others are notices. And I would like to see the statutory authority that allows you as a county court clerk or court judge to make a ruling on an appeal from another judge's court. Do you have that available?
Any other record? I'm going to give you, this isn't a back and forth, Mr. Schmidt.
I'm done.
So it's not a dialogue. I'm allowing you to make the record, I rule, and then we go forward. So you have additional, probably about 2.5 more minutes if you'd like to make any additional record.
Did you rule on your appeal yet? If not, then it's on hold under an appeal, interlocutory appeal. It's an automatic stay.
Any other record? You still have time to make any additional record that you'd like to make.
I yield.
Okay. Based on the record I've already filed and made an extensive record at the last hearing regarding the interlocutory appeal issue, I have found the court has jurisdiction. I'm not going to revisit those. What we have done now, Mr. Schmidt, is you've created a record. If you find that I've made mistakes, you can always appeal me, but ultimately we're set for trial next week. And so for the prosecution, you will be ready to proceed?
Yes, Your Honor.
Mr. Schmidt, will you be ready to proceed?
Nope.
And what is the grounds?
That you're incompetent.
Sir, I will not sit for you insulting the court. You could be held, sir, I'm just going to give you a quick warning. You could be held in contempt of court if you are violating the court's orders or the court's decorum. You're facing up to 6 months in jail. So we are talking about.
Now we move to our final hearing, which follows up on a sovereign citizen I've covered before. Last time, he was relying on terrible advice from someone claiming to be a licensed federal attorney, and things haven't improved by now.
Will you be ready to proceed for trial?
No,
Okay, are you moving to continue?
I do request to continue.
What is the grounds?
That I have filed an appeal already, interlocutory appeal.
For the prosecution, what's your position on the defense's motion to continue?
I'd object to that motion.
Okay. Based on the record before me, I've already denied that request or made a record regarding interlocutory appeal. I find that the defense has not raised good cause to continue the trial. Any other record, Mr. Schmidt, I'll allow you to make for 2 minutes. Okay. Your trial is the only case set on Thursday, so you should be ready to proceed. Has the prosecution have any notice that he's picked up discovery?
I can check on that, Your Honor. Should have a letter if he did. I'm not seeing that he has picked up discovery.
Okay.
We normally have a letter that he has, but it's not in our file.
Mr. Schmidt, if you want to know the evidence that's against you, you need to stop by the district attorney's office and pick up discovery. You ultimately need to be prepared for your trial. So it's your choice if you decide not to pick up the discovery. Discovery is the evidence that the prosecution will present at your trial. I will just tell you that we have certain very strict procedures for trial. I would suggest that you watch a trial before next Thursday so you have an understanding of what's going to happen. You have made arguments that I have ruled are not based under the law. And I will tell you that I will not allow you to make those arguments before a jury because the jury is going to make a determination as to the facts of the case and whether you are guilty or not guilty of the offenses charged. So I just want to set your expectation that you will have to proceed to trial with an understanding that the court will not let you raise those arguments. You've already raised them. I've denied them in a lengthy hearing. I've also denied them in writing. So on the day of trial, I'll explain quickly the procedures of trial, but ultimately you'll have to make a decision of how you are going to proceed. You've had a gentleman here with you previously. I've made it clear that he cannot represent you. He is not a licensed attorney who has entered on the case. He cannot help you during trial. You cannot whisper to him. I allowed for you to talk with him during the motions hearing, but this is different for jury trial. So ultimately, if you would like to be represented by an attorney for the public defender's office, Colorado does not have a procedure where I force an attorney upon you. You must apply for the public defender and show that you qualify. At this point, you've made choices not to be represented. If you qualify for the public defender, then you can have an attorney enter on your case. You can hire an attorney. Ultimately, trial is next week. You've raised these legal arguments. I've denied them. We're proceeding to trial. And so you should be ready with the evidence picking up the evidence and understanding what evidence is against you. Any record, Mr. Smith, that you'd like to make, I'll give you 2 minutes.
He is a licensed attorney, federal licensed attorney. 7406. If you'd like to look it up.
You have about 1 more minute if you'd like to make any other argument.
If you don't want to be called a sovereign citizen, then stop behaving like one. And if you don't want people calling you a domestic terrorist, reconsider the behavior behind it for everyone to see completely.
Practice law, he's not filed a formal entry of appearance, and so he cannot represent you. You'll be representing yourself unless you take steps to hire a licensed Colorado attorney or you apply for the public defender. Trial is set at 8 a.m. on June 4th, and so everyone should be prepared to proceed on that date. For the prosecution, do you have that information on how he can pick up discovery?
I do, Your Honor. I have a piece of paper right here.
Okay, all right. And for the record then, Ms. Hanine is handing that to Mr. Schmidt. Mr. Schmidt, you can take steps to pick up the discovery in the case. And ultimately, for the prosecution, did you want to lay out for the record what the plea offer is in the case?
Sure, Your Honor.
And just for the record, under the law, the court is going to have the prosecution make what's called a lawful record, which is a record regarding the plea in the case. So Mr. Schmidt understands what plea offer he's rejecting.
So, Your Honor, I haven't been able to convey this to Mr. Schmidt yet. He refused to talk to me without his friend present. I didn't feel comfortable doing that. I don't think his friend understands that he is not his attorney. But I would dismiss the case if he obtained Colorado insurance.
Mr. Schmidt, did you understand that if you get Colorado insurance, the prosecution would dismiss the case? We can proceed to trial. Ultimately, I think I've talked to you already about the possible penalties that you're facing, but it's your choice if you decide not to get insurance. But if you'd like to take the prosecution up on that plea offer, you can contact them. Any other record, Mr. Schmidt? I'll give you 2 minutes.
I do not understand. I do comprehend.
Okay, you have 2 minutes.
I yield.
Okay. Good luck. We'll see you back here on June 4th at 8 a.m. Don't be late. If you're even 15 minutes late, you can have a warrant for your arrest.
And that's the end of today's video. 2 of these defendants still have court dates ahead, while the third has already lost his case. 3 cases, 3 disasters, and somehow everyone managed to make things worse than before. If you enjoyed the video, hit like, leave a comment, and subscribe with notifications on so you don't miss the next one. See you next time for more soon.